the next meeting, and anybody else who wants to go downstairs and actually see the studios and how they work.
Oh, fantastic. Good.
Okay. So, members, I think we're back in public session here, so our meeting is now back open to the public. So, just to reiterate the outcome of our discussions with broadcasting, so we have agreed that some of the issues that we've experienced over the last number of weeks have been investigated. We're satisfied that a solution to some of those issues has been found. However, we need to just keep a watch and brief over the next few weeks and hope that all the gremlins in the system have been ironed out. And if we need to ask Michael Kearns to come back and provide a further update, the committee has agreed that we will seek further clarification from Michael and his team if we experience any more technical difficulties, which I hope we won't. So, members, will move on to agenda item 5, and this relates to Schedules 6A and 6B of the Northern Ireland Act, and we will be getting a briefing from some officials on this. So, just to remind members that the Windsor Framework Democratic Scrutiny Committee wrote in March 2024, highlighting that it is not currently provided for in standing orders, unlike other standing committees, and asking that the Committee on Procedures consider taking forward the drafting of a standing order to address this. The Windsor Framework Democratic Scrutiny Committee also asked this committee to undertake exploratory work to identify options that would provide in standing orders for substitute members for it, rules on substitution, and for proxy voting. Following our strategic planning event on the 10th of April, this committee decided that one of the priority areas of work it would take forward would be consideration of Schedules 6A and 6B of the Northern Ireland Act 1998, and whether there should be any provisions made in standing orders in relation to the democratic consent process and or to reflect the arrangements for the Windsor Framework Democratic Scrutiny Committee, the Stormont Break and applicability motions. So, to assist in the committee scrutiny, Assembly officials have agreed to attend today's meeting to provide a briefing on Schedule 6A and 6B, and this will be followed by legal advice requested by the committee on the requirements, if any, to make provisions in standing orders. You'll find the relevant papers, including a briefing paper on Schedule 6A and 6B and the letter received from the Windsor Framework Democratic Scrutiny Committee at pages 17 to 63 of the meeting pack. So, members, I want to welcome Paul Gill and Shauna McGeehan, Assembly EU Affairs Manager, and Paul is the the Clerk Assistant, to the meeting, and invite them to briefly outline the issues and the contents of Schedules 6A and 6B of the Northern Ireland Act 1998. So, over to yourselves, Paul.
Thank you very much,
Shauna.
Deputy Chair and members, for the invitation to attend today. So, as Deputy Chair said, we're here to talk about the relatively new Schedules 6A and 6B to the Northern Ireland Act 1998. Schedule 6A sets out the arrangements for the democratic consent mechanism. So that is the process by which the Assembly is asked whether it wants Articles 5 to 10 of the Protocol or the Windsor Framework to continue to apply. And it was first identified as an issue that this committee might want to look at actually by your predecessors in its legacy report, which was back in March 2022. Of course, at that time there was no Schedule 6B. It was a year actually after that then that the Windsor Framework Agreement came about, and it provided for various democratic scrutiny mechanisms, and they've since been given effect in domestic law by Schedule 6B. It was the Speaker, therefore, that drew Schedule 6B to this committee's attention, as well as referring to Schedule 6A. And the reason for that is that where the law has been changed in a way that affects the procedures of the Assembly, then it's absolutely right that this committee should really examine what those legislative changes are. And it needs to do that, I think, in the first instance, to be clear about what effect they have on Assembly proceedings, how things are going to change. But secondly, and just as importantly, to identify whether further work might need to be done by this committee to supplement those changes, and that might be done through changes to or the introduction of new standing orders. So the Speaker had therefore asked the committee to consider, in relation to Schedule 6A, whether there should be any further provision in standing orders in relation to the democratic consent process, particularly given that the first notification is actually due to be sent to the Assembly by the Secretary of State before the end of this calendar year. And then as far as Schedule 6B is concerned, the Speaker invited the committee to consider whether standing orders should be made to reflect the arrangements for the Windsor Framework Democratic Scrutiny Committee, for the Stormont Break and for applicability motions. So I know you're due to get legal advice today in relation to both of these schedules, but before you get that, we thought it would be helpful to provide you with an introductory paper. So Shauna, as our EU Affairs Manager, has prepared a paper for you, and Deputy Chair has referred to you having that in your packs, and that summarises the key elements of Schedules 6A and 6B. So if you're content, I will hand over to Shauna, who will talk you through the paper.
Thanks, Paul. Thank you, Deputy Chair and members. So, as Paul said, I'll start with, sorry, I'm a bit hoarse, apologies in advance. I'll start with Schedule 6A, which, as Paul said, deals with the democratic consent mechanism. And one point of note here is that the democratic consent process is entirely separate to and unaffected by the arrangements set out in the Windsor Framework regarding democratic scrutiny. So the protocol agreed between the UK and the EU in October 2019 has 19 different articles. Articles 5 to 10 of the protocol, or Windsor Framework, contain provisions on customs, movement of goods, EU single market regulations, VAT, excise and the single market, and state aid. Essentially, this means that Northern Ireland continues to align with many EU rules in order to maintain access to the EU single market for goods. So Article 18 of the Protocol Windsor Framework contain provisions for a democratic consent mechanism, that is a vote by the Assembly on whether Articles 5 to 10 of the Protocol should continue to apply. The Protocol on Ireland Northern Ireland Democratic Consent Process EU exit regulations give legal effect to this process and inserted the new Schedule 6A into the Northern Ireland Act. With the democratic consent mechanism, the first vote must be held by the Assembly by the end of 2024, that is 4 years after the end of the transition period. You have a flowchart in your packs, I believe at page 25, which details the various stages in the process, and there are specific timelines which apply for the democratic consent process. The dates in the flowchart in your pack are those which will apply to this particular year, 2024, and are taken from the explanatory memorandum on the regulations prepared by the government. So the process begins with a notification by the Secretary of State to the Speaker and the First Minister and Deputy First Minister. The First Minister and Deputy First Minister, acting jointly, may table a motion on democratic consent. If this is not tabled before the start of the final month, i.e. December this year, then any MLA can table the motion. If the motion has not been considered before the final 15 days of the period, i.e. 15 days before the end of the year, the Assembly must sit on the required day, whether or not the Assembly would otherwise be sitting and whether or not that day falls during recess. So the wording of the motion is actually set out in the schedule. It basically says that Articles 5 to 10 of the Protocol on Northern Ireland to the EU withdrawal agreement should continue to apply during the continuation period within the meaning of Schedule A of the Northern Ireland Act. The motion is to be decided without amendment and cannot be subject to a petition of concern. And continuation period really refers to the time before the next vote, so either 4 years or 8 years, which we'll come on to now. If the motion is passed by a majority of MLAs, the next vote will be held 4 years later. If the motion is passed by a majority of MLAs and has cross-community support, the next vote will be 8 years later. And cross-community support for these purposes follows the definition that's within the Northern Ireland Act as the support of a majority of members voting, a majority of designated nationals voting, and a majority of designated unions voting, or the support of 60% of members voting, 40% of designated nationals voting, and 40% of designated unionists voting. If the motion is passed only with a simple majority, i.e. without that cross-community support, the Government has stated it will commission an independent review into the Windsor Framework and its implications. The other articles of the Windsor Framework, out with Articles 5 to 10, will remain in force regardless of the outcome of the democratic consent vote. And for example, other articles in the protocol are Article 2 around human rights and rights of individuals, the common travel area, etc. So the vote purely is confined to Articles 5 through to 10. If the Assembly votes against the motion, Articles 5 to 10 shall stop applying after 2 years. The UK-EU Joint Committee is the governance body co-chaired by the UK and the EU which oversees the withdrawal agreement, including the Protocol Windsor Framework. And if the vote is not passed, the Joint Committee will make recommendations to the EU and UK on any necessary measures taking into account the obligations of the parties to the 1998 agreement. And before doing so, the Joint Committee may seek an opinion from institutions created by the 1998 agreement. The regulations also provide that where the Assembly has passed the resolution but without cross-community support, the Secretary of State will commission this independent review I've mentioned already. This review says that it may include consideration of any effect of the Windsor Framework on the constitutional status of Northern Ireland and the operation of the single markets in goods and services between Northern Ireland and the rest of the UK. This independent review will make recommendations to the Government, including on any new arrangements it believes could command cross-community support. And a separate piece of regulation, the Windsor Framework Constitutional Status of Northern Ireland regulations, give further details about what that review may do. The Government has also stated it would appoint an independent monitoring panel for the Windsor Framework, and that panel would support the work of any independent review. The report on the independent review will be laid before Parliament and also sent to the Speaker to be laid in the Assembly. The schedule also provides for an alternative process, democratic consent process, which would apply if the offices of the First Minister and Deputy First Minister are vacant and their functions are not otherwise being exercised by another Northern Ireland Minister. The alternative process also provides for a situation where the election of a Speaker is required to be the first business on that day and the Assembly does not elect from amongst its members a Speaker. In these circumstances, an interim Speaker would be elected. Standing orders may make further provision in connection with the election of the interim presiding officer or Speaker. Chair, I'm happy to pause there in relation to Schedule 6A or move on. I'm entirely at your disposal.
Members have any questions at this point, or do you want to move on to the 6B?
Can I just go back to the previous one that you were just talking about?
Yeah.
In the absence of First Minister and Deputy First Minister, the procedure would be that the Assembly elects a Speaker, and if no Speaker is elected, then an interim Speaker is elected?
Right.
Okay, and is that just by the same process that we would have elected a Speaker?
Yeah, I think the best way of looking at this alternative process is that the Government were wanting to deal with the situation that we've had last year. So what happens if the Assembly wasn't up and running? So not only did you not have any First Minister and Deputy First Minister in place, you also hadn't had a Speaker elected. And obviously the first item of business the Assembly has to do is to elect a Speaker, and that's why we weren't meeting, because we couldn't get past that first item of business. The Government wanted to ensure that irrespective of what the political situation was here, there was going to be a mechanism in place that would allow the Assembly to take a vote on this particular matter. So it essentially said, even in those circumstances, if you've got no FM and DFM, even if you don't have any presiding officer, these are the arrangements that we're putting in place to allow there to be an interim presiding officer who doesn't have to be elected with cross-community support. So all those MLAs who aren't coming to the chamber every week can come in for this one day and still have a vote on this matter. So it's, if you like, an insurance mechanism, just in case we ever found ourselves in those circumstances again. But obviously where we are now, we'd all hope and expect that that insurance mechanism wouldn't need to be used.
Sorry, just through the chair. So in the case of an interim Speaker, electing an interim Speaker is done not by cross-community vote?
That's correct.
So it is just simple majority?
A simple majority.
And it would be only for that one item of business, which would be the democratic consent vote?
That's right.
Okay, thank you.
Okay. And no members online have indicated no. Do you want to move on to 6B?
Yep, I'll do. Thank you, Deputy Chair.
Yep, thank
So
you.
Schedule 6B deals with the Windsor Framework democratic scrutiny. The Windsor Framework was agreed between the UK and the EU in February 2023 and contain new mechanisms for engagement of the Northern Ireland Assembly on EU law, which is applicable under the Windsor Framework, formerly the Protocol. In March 2023, Parliament approved the draft Windsor Framework Democratic Scrutiny Regulations, and these regulations were made by the Secretary of State in February 2024. And members will recall that the Secretary of State wrote to the Speaker, then Speaker, in February, once he had made the regulations, set out arrangements for the operation of the various provisions, and the Speaker did circulate that letter to all members. So these regulations inserted a new Schedule 6B into the Northern Ireland Act and set out arrangements for three elements: establishment of a new Windsor Framework Democratic Scrutiny Committee of the Assembly, the process by which members of the Assembly may seek to prevent the application of a replacement EU Act under the Windsor Framework, i.e. the Stormont Break, And thirdly, provisions relating to the position of the UK in the EU-UK Joint Committee with respect to any proposed application of new EU acts to Northern Ireland under the framework through the establishment of an Assembly position on a debate on applicability motion. I'll set out now the details of each of the three. So moving firstly to the Windsor Framework Democratic Scrutiny Committee, it's the new standing committee of the Assembly. And the purpose of the committee is to assist with the observation and implementation of Articles 13.3a and 13.4 of the Windsor Framework. These essentially are the parts of the Windsor Framework that set out how EU law should or could apply in Northern Ireland. Article 13.3a deals with amending or replacing acts, i.e. this is changes to the volume of EU law that's in Annex 2 of the protocol that already applies in Northern Ireland. Article 13.4 deals with new EU acts that the EU deems within the scope of the Protocol Windsor Framework and may apply to Northern Ireland. So the Windsor Framework Democratic Scrutiny Regulations set out the committee's function, and those are the examination and consideration of new EU acts and replacement EU acts, the conduct of inquiries and publication of reports in relation to replacement EU acts, engagement with business, civic society and others as appropriate in relation to these acts, engagement with the government in relation to replacement EU acts, engagement with ministers and Northern Ireland departments in relation to EU acts, replacement EU acts, collation and publication of evidence collected, and dealing with any other matters, including legislative proposals which may become EU acts or replacement acts, which the committee considers to be connected with its purpose or functions. So for proposed EU acts, that is pieces of EU legislation that are in the pipeline, if you like, so they've been proposed by the European Commission but haven't yet been agreed by the EU institutions and are therefore not yet law, the government may notify the committee about these new or replacement EU acts which have been proposed by the European Commission. The committee can then choose to monitor the progress of this legislation and may choose to publish interim reports and hold inquiries. For published EU acts, i.e. law that has been adopted by the EU institution and is now law across member states, the government may notify the committee about amending or replacement EU acts which have been formally agreed and published in the EU's official journal. For these published replacement acts, the committee has a statutory duty to decide whether to hold an inquiry into that act and must publish its decision. The committee has 5 working days from the date of notification by the government to decide whether or not to hold an inquiry. In holding the inquiry, the committee must have regard to whether the amending or replacement EU Act significantly differs in whole or in part from the content or scope of the instrument that it replaces or amends, and would have a significant impact specific to everyday life of communities in Northern Ireland in a way that is liable to persist. In carrying out the inquiry, the committee must engage with the government, a minister in Northern Ireland Department and representatives of business and civic society who may potentially be affected by this EU Act. Following its inquiry, the committee must publish its inquiry report no later than 15 working days before the end of the 2-month scrutiny period. And this 2-month period begins once the EU Act is published in the EU's official journal. And the flowchart at page 31 in your packs shows this process. There are a number of timelines that must be abided by here. In this letter to the Speaker in February, the Secretary of State outlined that the government intends to notify the Windsor Framework Democratic Scrutiny Committee of relevant proposed and published EU acts on a weekly basis and to provide the committee with explanatory memoranda on this legislation. Moving on to the storm and break. This is the process by which MLAs may seek to prevent the application of a replacement EU law. Under the protocol, over 300 pieces of EU legislation apply in Northern Ireland, and these are listed in the Annex 2 to the protocol. When EU laws in that list are amended or replaced, the changes automatically apply in Northern Ireland unless the storm or break is applied. Under the break procedure, 30 MLAs from at least 2 parties in the Assembly can notify the UK Government of their wish that the emergency break in EU law is pulled, i.e. that they wish to stop the application of this amended or replacement EU law in Northern Ireland. And you have a flowchart at page 34 in your packs that shows the various stages. There are conditions for the use of the break. The Northern Ireland Executive must be operational and the Assembly in regular session. The MLAs who wish to pull the break must explain how their notification is being made in the most exceptional circumstances and as a last resort, having used every other available mechanism. They must explain how the content or scope of the amended or replacement EU law significantly differs from the original law and how its application would have a significant impact a significant impact specific to everyday life of communities in Northern Ireland in a way that is liable to persist, and they must demonstrate that they have sought prior substantive discussion with the UK Government and within the Northern Ireland Executive to examine all possibilities in relation to the EU Act, taken steps to consult businesses, other traders and civic society, and made all reasonable use of applicable consultation processes provided by the EU for new Union Acts relevant to Northern Ireland. In notifying the Government, MLAs must provide a detailed and publicly available written statement to demonstrate that they've met all those above conditions. And this notification must be provided to the Speaker no later than 10 working days before the end of the scrutiny period, this 2-month period since it was published in the EU. Then, if the Government is satisfied that those various conditions have been met, it will notify the EU in that joint committee. This notification must be made within 2 months following the publication of the EU law and must include a detailed explanation of the UK Government's assessment regarding the conditions set out above. If the EU thinks the Government's explanation is insufficient, it can request further information. If the brake is pulled, the EU law will not apply in Northern Ireland in its new form 2 weeks later or 3 days after the UK has provided further explanation, and the older or unamended version of the law will apply. At this stage, that replacement law is discussed with the UK and the EU in the Joint Committee under the process they use for new EU laws 13.4. And that brings me on then to the final provision of Schedule 6B, Deputy Chair, which I'll cover now, and that relates to how proposed application of new EU law in Northern Ireland, and this relates to the applicability motion process. As I mentioned previously, Article 13.4 of the Windsor Framework sets out the process for new EU law to be added to the list in the Windsor Framework. The EU must inform the UK in the Joint Committee if it considers a new EU law to be within the scope of the framework, and it can only be added to the list of EU laws which apply under the framework to Northern Ireland if the UK agrees to this. Under the provisions of the Windsor Framework, the Government will not agree in the Joint Committee to add a new EU law to the framework unless the Assembly has indicated cross-community support by passing an applicability motion. So the Government will provide a notification to the Assembly that a new EU Act is being considered in the Joint Committee. The First Minister and the Deputy First Minister may table an applicability motion in the 2 weeks following the notification. Following this 2-week period, any MLA may then table the motion. The wording of the motion is set out in Schedule 6B. It says that X, i.e. the relevant EU law, should be added to the Windsor Framework by the UK and EU within the Joint Committee in accordance with Article 13.4 of that framework. The vote must be passed with cross-community consent and must be passed within 5 weeks of the notification by the Government. And these time periods can be expended by a UK Government Minister. There's a flowchart on page 38 of your pack, which again demonstrates the process and shows the various timelines. The Government has said that they won't agree to the law applying in the EU unless the applicability motion has passed. However, the Government has said that it may agree to the law applying in Northern Ireland even if no applicability motion has been passed, if they deem that there are exceptional circumstances, including if there's no Assembly or Executive, or if the new EU law would not create a new regulatory barrier between Great Britain and Northern Ireland, and they refer to that new regulatory barrier as material diversion of trade or material impairment of the free flow of goods. If the Government does propose to add the new EU law to the framework in one of these cases, it must make a statement to Parliament explaining the reasons for its decision, and the Government has said it also intends to notify the Assembly of such a decision. If the UK and the EU do not reach an agreement in the Joint Committee about adding the new EU law to the framework, they have said they will examine all further possibilities to maintain the good functioning of the Windsor Framework and take any decision necessary to this effect. If they can't come to an agreement and no decision is made within a reasonable time, the EU may take appropriate remedial measures. And there's a whole gamut of remedial measures. These could be tariff barriers, etc. The process for new EU law to apply in Northern Ireland is set out in your packs, and this process will also apply in the case of amended law where the storm brake has been pulled and that law has moved through that process. So, to summarise, Deputy Chair, applicability motions apply when the EU adopts a new piece of legislation which it considers to be within the scope of the Windsor Framework, and the storm brake applies to an EU Act which amends or replaces the list of EU legislation that already applies under the framework. So that's a very quick gallop through it, Deputy Chair, so I'm very happy to take questions.
Thank you, Shauna. Yeah, that was indeed very detailed in solidarity with our colleagues on the Windsor Framework Democratic Scrutiny Committee. They certainly have their work cut out for them. And I suppose that was a very high level, it was fairly detailed in terms of the work of the committee. Yeah, and not that we have to concern ourselves with the detail that they're dealing with, but I suppose it is important for us to have an understanding of what they're dealing with and how it works and the volume of issues that are coming across their desks on that committee. And I suppose the work for ourselves is the chair had written to the chair of the Democratic Scrutiny Committee to say, look, how can we, outside of what is already within the remit of your committee, how can procedures through the drafting of a potential standing order assist you with your work or make that easier. So I suppose we did receive correspondence from the chair to say that firstly, they're not provided for in standing orders, so that's a bit of an anomaly. We have a new standing committee that aren't listed on anywhere. So unless somebody thought to ask, they wouldn't know that we have the Windsor Framework Democratic Scrutiny Committee. So I suppose they were keen just to be recognised, I suppose, in the first instance and provided for in standing orders. And then some of their other asks were around substitution of members and around proxy voting. And I suppose the value of getting the detailed briefing from yourself, Shauna, was just to prove the workload that they have, that it's not like the other standing committees where there are possibilities that it would need to work in times of recess, for example. So people will appreciate that members may be on holiday or may not be available at those times. So does it stand to reason then that we would lay a standing order or make a new standing order that would allow for a substitute member or for proxy voting, just to ensure that necessary work that committee is undertaking can flow and can happen. So that's the question that we are faced with. And I suppose and I know we're getting legal advice after this as well. The question for us is, firstly, legally, is that what we should be doing, or is there anything else outside of what the committee has asked for that you think that we should be providing for in standing orders, or is it within the remit of the committee, the parameters that are already set for that committee? Is that enough to enable them to do their work, or is there something else that we should be thinking of or considering?
Yeah. Deputy Chair, I think the two issues that you've touched on there are the two key issues as far as we would see it. First of all, yes, there is a lacuna in standing orders by there not being a reference to the standing committee, or standing orders are incomplete really until there is provision made for the committee. The second issue then, yes, the committee is going to have challenges because of these very tight timeframes. So it's not just that the committee might have to meet over recess periods. In theory, any committee could meet over a recess period if it wanted to. That in itself isn't the issue. It's the fact that they might have to do that at very short notice, because there's a statutory turnaround of 5 days. And with the committee having no control really over when those notifications are made to it, there is provision for it to talk to the Cabinet Office to see if it could manage that flow and there not be referrals at certain times. But ultimately, if something is published, then it needs to be referred to the committee and those statutory deadlines kick in. So it may be through no fault of a particular member that they in good faith think that they don't have any committee meeting over the next week or so and aren't available, and then hear that they are going to have to come. And that's where I think the issue of substitute members comes in and really would be something that could help that committee. I know they've mentioned the issue of proxy voting as well. I think substitute members in the first instance is probably a key, at least in the short term, that could help them here, because it's already something that we have at the Assembly. At the Business Committee, for example, there's provision in standing orders there that if a member of the Business Committee isn't available, then a substitute member can attend on their behalf. So if this committee was minded to bring forward a standing order to provide for there to be a Windsor Framework Democratic Scrutiny Committee, it wouldn't change the fact that that committee exists and can carry out its business. That will happen irrespective of whether there's a standing order, but it could go further and make provision for there to be a substitute member, and that would, I suppose, provide greater resilience or reassurance to ensure that the committee could continue to meet its statutory duties where those notifications are made.
I suppose obviously we're looking at proxy voting for parental leave.
Yes.
And I suppose further down the line, we will, I assume this committee will look to expand that for other instances. And then you obviously, the natural question then is, do we have that in committee as well? And if we're making it for this committee, do we go ahead and provide those standing orders for other committees as well? Or do we just make sure that this, given the nature of its work, that that's the priority?
Yes.
So I suppose that's something we need to consider as well.
And I'm aware that, yes, that you're going to come to that on proxy voting, and in due course you'll be looking at it more broadly. That's why I think in the short term, something around substitute members is something that could work well for that committee, because you'd be able to take a decision in relation to that committee as a standalone issue without having to look at the broader policy and where you've reached on that for all committees around proxy voting. I do think, and I mean, I know you'll be getting legal advice later on, but if you were ever minded to look at the issue of proxy voting for committees, it'd be some specific legal issues that you would need to look at, because there are specific legal functions of that committee that it needs to carry out. It needs to have due regard to certain matters, and I think you'd want to be satisfied that any arrangements you have in place provide to ensure that any vote taking place at that committee demonstrated that those legal requirements had been met. So it maybe gets a bit more complicated with proxy voting, whereas with substitute members, where you have somebody else who can come along at short notice, who can hear all the evidence in front of them and then can contribute to the committee's decision making, having taken account of all those factors, is something that would be more straightforward.
Well, that's very useful to know in terms of the difference between substitute and proxy. A couple of members have indicated, so I have Danny and then Militia. So Danny, do you want to go ahead?
Yeah, just a couple of questions. Just in relation to the committee, the Windsor Framework Democratic Scrutiny Committee. When their decision to hold an inquiry, is that based just on a simple majority within the committee?
Yes.
And there's the other one then, the applicability motion, obviously, as a cross-community support. Obviously, I would be disappointed with that as somebody who doesn't designate. And we would feel that obviously the Alliance Party would be discriminated against then, because our votes wouldn't be counted the same within that. A couple of questions just about the substitution. The way it works, I know you've said there's a precedence there for the business committee. So does somebody nominate a substitute who remains their substitute for the duration of the committee, or is the substitute flexible, dependent upon each meeting? Because if the substitute is flexible, there could be a completely different membership to the committee from one week to the next.
Yeah.
How does that work?
Well, as far as the business committee is concerned, it doesn't have to be a designated substitute, but that's not to say that for this particular committee, if you felt that that was something that was worthwhile, that you could have in place a substitute that was identified in advance. So there'd be scope to look at that, and you might, if you're going to engage with the Windsor Framework Democratic Scrutiny Committee further, you might ask them if they have a view as to whether or not they think that would work. But ultimately, I think as far as the standing orders are concerned, you could go down either of those routes.
In relation to getting committee packs and things, would the substitute get all the committee packs prior to the meeting?
They would have to, and I mean that would be important in the case of any committee, but with this committee, where there is a statutory duty to have regard to particular information, and that information is going to be set out in the pack, they would really need that information in order to be able to take the decision at the committee.
I would assume there's a lot of reading involved and a lot of background and things like that. Would the substitute's contribution and any subsequent votes within the committee, would that be registered differently? Would it be highlighted that the person is a substitute?
The minutes would reflect that member B had attended in place of member A, but as far then as once that was recorded, their votes would be treated in exactly the same way as the original member of the committee, so the committee would still be able to take a decision. In fact, I mean that's really the whole purpose of why you would have that arrangement in place, to allow the committee to continue to take those decisions.
Absolutely, I can see that. That's great, thank you.
Thank you, Danny. Militia?
Seanna, agus Paul, Cormier, Agov, Talan, all of on, you have a lot of information there. Your head will be kind of buzzing just. And I wanted just in terms of the actual committee itself, and who's the final arbitrator when it does come to the implementation of, or even the acknowledging that there's an area of conflict as far as new law is concerned. And does it have the potential, even within the committee itself, then to frustrate legislation?
No, I mean, there is a relationship, obviously, between the committee and the break, but it is important to say that the view that the committee takes on the legislation as to whether or not it has a significant impact or whether or not it significantly differs, that doesn't restrict or dictate whether 30 members of the Assembly may seek to apply the Stormont break. So it might inform their decision. And we would hope then through the committee publishing reports that all members of the Assembly will be able to say, okay, this committee's had a chance to look at this, here's all the evidence they've gathered. Do we now feel that this new or this amended law is going to have a significant impact? But the committee could take one view and 30 members could say, well, that's fine, but actually we disagree with the view that committee's taken, and irrespective of that, we're going to seek to apply the break anyway. And if they wanted to do that, then the various different conditions that Shauna had set out there would apply, and they would have to make a notification to the Speaker and demonstrate how they felt the different criteria had been met.
And in terms of the break, then the final arbiter actually in it then is the Westminster government themselves.
That's right, because once then that notification goes to the UK government, they need to be satisfied that those conditions have been met, and if they are satisfied, then they'll go to the joint committee, and then those various different steps that Shauna has set out will follow from that. So there are quite a lot of different steps in this process.
Thank you, Malaysia. Orlia? Yes, thank you. So just quickly on the Stormont break, is that determined by cross-community support as well?
No, the break itself is just 30 members. So there are different criteria. They must come from more than one party. They can't include Speaker or Deputy Speaker, but there isn't a requirement that they need to have a cross-community a section of members from across the communities. It could be 30 members from all one designation.
Okay, and then I just wanted to ask around so if this committee was to introduce a standing order to recognise the Windsor Framework Committee as a standing committee, when you're talking about then substitute members and stuff, would that have to be a separate standing order, or could that fall under the standing order where you're deeming the committee as a standing committee? The way you can then get into detail under guidance and description and stuff, would that need to be a separate standing order that the committees?
I would imagine, and obviously legal services would take this away and prepare a draft for you and you could have a look at it, but the way we have it for each of the other standing committees at the moment is that there is a single standing order that usually has a number of different parts to it. Right. And the first part of it might just say what the name of the committee is and some sort of summary of what its role is, and then subsequent parts to it then might set out any further additional detail that apply just to that committee. So you could have a standing order that provided for the Windsor Framework Democratic Scrutiny Committee, and that it would have the functions as set out in Schedule 6B of the 1998 Act, and then anything else would obviously have to be consistent with that, but there'd be nothing inconsistent with the legislation to then go on to say substitute members may attend the committee in whatever arrangement either this committee or the Windsor Framework Committee has agreed.
Okay, no, it's useful to know. Just
I suppose that was clarification I was going to seek as well. Do we look at two separate standing orders here, or is that just we provide for it, and then, as you say, the list of functions after that flow from it?
No, it'd be a single standing order, but with, as I say, a couple of different parts in it would address all of that.
I suppose then the work for us then is to, I'm sort of guessing that you've said there could be legal ramifications around the proxy voting element to this here, so going down the substitute member route may be not a quick win, but it may be easier managed or easier implemented. In
the short term, yes, and it also means then that because you have plans to look at the broader application of proxy voting, you can do that on a consistent basis when you come to it, but at least in the meantime the Windsor Framework Democratic Scrutiny Committee doesn't have to wait and deal with this issue of, well, what happens when we do have these notifications at short notice that we weren't expecting.
Okay. I don't think any other members have indicated, so listen, we'll leave that there. Thank you very much, that was very useful, and Paul, I know you're staying with us. Thank you very much, Shauna.
Thanks,
much appreciated. Okay, just to advise members, as I said, Paul is going to remain with us for the next agenda item.
which is the legal advice on Schedules 6A and 6B. Agenda item 6 then is the legal advice on the Northern Ireland Act. So the committee will now consider the legal advice in relation to Schedule 6A and 6B. So can I seek agreement from members that we move into closed session in accordance with the normal procedure for receipt of legal advice?
Committee Room 21. Sound. 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 Committee Room 21. Sound.
Thank you. So, are we in? Just clear to go.
I think they are. The lights of the cameras have come up. Yeah, we are.
Yes, thank you. So, members, can I seek agreement from members to, in terms of agenda item 8, that we, in relation to the executive legislative timetable debate, we were due to get some legal advice, but we're under some time constraints now, given the other previous items and the length of time they've taken. So can I get agreement from members that we defer agenda item 8 on the executive legislative timetable to our next meeting of the 12th of June?
Yep, great.
Thank you. Thanks, members. Okay, so if we move on to agenda item 9, which is in relation to proxy voting for parental leave in plenary, members will find information on the relevant papers at pages 114 to 138 of your meeting pack. And the clerk's memo is at page 114 and 115. This provides an update on the position in relation to the committee's ongoing consideration of proxy voting for parental leave in plenary. 2 responses have been received from other MLAs, from Jerry Carroll, People Before Profit, and from Paula Bradshaw of the Alliance Party. They've been received, and the committee's obviously went out and asked for the committee's request for review, so we have those 2 back. Those are at pages 116 and 122 of the meeting pack. In terms of the guidance, one issue the committee was unable to resolve was whether there should be a deadline for the notification to the Speaker, and it was agreed that the Business Office should be contacted to establish the rationale for the 9:30 a.m. deadline for the notification of proxy voting arrangements during the COVID pandemic. The Clerk Assistant, Paul Gill, will attend the meeting on the 12th of June to outline the rationale for the deadline and answer any questions on this. So just to advise members that the research that we requested on the registration of people as foster carers is now available and is provided at pages 128 and 133 of the meeting pack. The research, the briefing by Paul Gill and the 2 responses and any others received will be considered at the meeting on the 12th of June, together with the legal advice requested by the Committee on Cross-Community Voting and the first draft of the standing order. Are members content with that? So agenda item 10 is the committee's forward work programme. You'll find this at pages 135 and 136 of the meeting pack. The committee, so let's see if the committee's, okay. So I think we're,
Or maybe, do you want me to just
yeah, because I think my
forward work
pack
programme?
isn't just maybe up to date.
Okay, just in relation to the forward work programme, we're now rescheduling the legal briefing until the 12th, and you're also going to schedule further consideration of a potential standing order for 6A and 6B. So on that basis, I think just looking at the forward work programme, we maybe need to defer the review of oral questions to the following meeting on the 26th of June.
Okay.
We're also due to do a proxy voting on the 12th, Stella.
Yes, there'll be quite a lot to consider there on the 12th. It'll be both the legal advice and your final policy decisions, as well as taking evidence on the rationale for the 9:30 deadline. So it's a chunky piece of work as well. So we'll try and schedule as much as we can, but there's going to be 2 or 3 chunky pieces of work. It'll be a lot.
There's further legal advice, but I think it should be
Could be
quite
a long
short
meeting.
on the standing order to provide the final deadline for introduction of a private member's bill, or a member's bill as it's now called. But I think it should be quite short. I need to check just with Alice to make sure she's available for the 12th. But I'm assuming if she isn't, we could put that one back to the 26th if members are content, just depending on her availability. I think members will be aware there's already the statement on the Executive's legislative programme has been published by the First Minister and Deputy First Minister, and I understand there is a debate scheduled now on the order papers. So that would be taking place anyway, so that maybe
Makes it less
less
pressure.
urgent, because that at least will have taken place, and then the committee can consider how it wants to put it into standing orders.
So obviously then that means there's going to be changes to our forward work programme, taking into consideration the items of business today and the stuff that we've obviously deferred. So are members content that we make those necessary changes to the forward work programme to reflect all that?
Yes, content.
Thank you, members. Agenda item 11 is correspondence. So can I refer members to pages 138 and 139 of the meeting pack? These are correspondence received since the last committee meeting. The chairperson of the Committee for Communities has written to this committee to consider the provision of clear procedural guidance and or criteria for when committee sessions should be open or closed, to include briefings in relation to bills which may be subject to accelerated passage. So I just need to remind members that Standing Order 66(2)(c) provides that the committee may resolve to sit in closed session. This is therefore an issue that affects all Assembly committees. So really what I'm looking agreement from members that we refer the matter to the chairperson's liaison group for initial consideration and reply to this committee, to the Committee on Communities, outlining the action taken. And depending on the response from the CLG, the committee may want to add it to the list of priority work items in due course. So, Christine, I don't know if you want to give a bit of background to this here, just so members are aware. So I think it's there's a bit of ambiguity about whether a request to go into closed session.
Yeah, I think the background to it is that the Committee on Communities was considering where it was asked by departmental officials to hold a briefing on they were briefing the committee on the need for accelerated passage for a particular bill. They asked for that to be held in closed session. So the committee had some debate around it. I think they took procedural advice and legal advice on it. But that's the background to why they've written to this committee on it. However, it would apply. I think it applies across committees. There's an inference in standing orders that business is held in public, unless a committee decides otherwise. So any decision around this would affect all committees. So I think probably the best forum for initial discussion on it would be the chairperson's liaison group, where all the chairs would be able to discuss it, and then depending on their views and whether they think there needs to be further work done on it, they can come back to this committee with their advice on it, if that's okay.
I suppose it's whether that was a one-off or whether there are the issues around requests for closed session and how appropriate or not that may be.
Yeah, I think it is. I think the way it's written at the minute, I mean, it's down to each committee and there's a lot of flexibility. So I think there would be issues that would need to be considered if we were going to move away from that. But I think probably the chairperson's liaison group, where all the chairs can have that initial discussion, is probably the first port of call, if you like, to see what they have to say and see whether they do think it would be useful or they may not think it would be useful before this committee starts to take any further work on it.
Alicia?
Yeah, just to clear, I was on communities and if that situation arose, and I can understand entirely why it is that the chair of the committee has asked for clarification on that, because it is significant, you know, and in particular that on that occasion the committee felt that it was inappropriate for it to be in closed session, and it was coming as a request, you know, like from the actual department itself. So it's important that we have clarity on that whole issue, you know.
Okay, yes. So are we content then that we bounce this back to the CLG for just to get an idea of whether this is a broad issue or whether it's maybe just particular to that one briefing or that one, you know, issue within communities? Yeah. Okay, thank you, members. So agenda item 12 is chairperson's business. Be glad to know there are currently no items to cover under chairperson's business. Agenda item 13, any other business? Do members have anything else they want to raise today? No. Okay. Agenda item 14, date and time, place of next meeting. So our next meeting will be scheduled to take place on Wednesday, the 12th of June at 10 a.m. in room 21 Parliament Buildings. So can I just advise members that brings our meeting to a close and the meeting is now adjourned. Thank you.
Thank you very much.
Thank you.
Committee Room 21. Sound.